This video is on probate in general and brought to you by the New Mexico Judiciary, presented by Judge Cristy Carbón-Gaul. The information presented in this video does not and is not intended to constitute legal advice. All information in this video is for general informational purposes only. Information in this video may not constitute the most up-to-date legal or other information. Viewers of this video should contact an attorney to obtain advice with respect to any particular legal matter. Only your individual attorney can provide assurances that the information contained herein is applicable to your particular situation. The views expressed in this video are those of the author or authors only.
Hi, I'm Cristy Carbón-Gaul. I'm the Bernalillo County Probate Judge. In this video today, I'm going to talk to you about probate in general. So probate is the process by which someone gets appointed to be the personal representative of your estate so that they can administer the estate. A personal representative is what used to be referred to as the executor of the estate. It's the same concept, just a different term that's used now. You may have to do a probate, whether you have a will or not. And so I'm going to talk about both of those scenarios. So when you have a will that requires, that in a probate is going to be required, then you file to be appointed as personal representative of the estate, and you file to have the will probated and deemed valid. And so when I'm working as the probate judge, I'm looking to make sure that the will was validly executed. And if the person named in the will is the person who is asking to be appointed as personal representative and the will is valid, then we appoint them as personal representative. That gives that person the ability to gather the assets of the estate, pay the bills, do the final tax return, make an inventory of the assets, and then eventually distribute those assets out to the beneficiaries that are named in the will. If there is not a will, then the New Mexico Probate Code provides a statute that says who has priority to be personal representative. And that priority is first surviving spouse, then it would be adult children. If there's not a spouse or a child, adult child, then it would be potentially the parents of the deceased person. It could also be a sibling or some other person that's related that's an heir of the estate. So the statute sets out who has priority to serve and in what order they have priority to serve. The statute also provides who the heirs of the estate are, which means the people who would become the beneficiaries of your estate. Because you don't have a will, the state fills in the blanks and tells you who those people would be. So that's either going to be, it's going to be a spouse, it's going to be children. If you don't have those, it's going to be parents and siblings, nieces and nephews, and it continues down the line. So we do probates when there's not a will, and we do probates when there is a will. And so really what it comes down to is, do you need a probate? There is a misconception out there that everybody who dies needs to go through probate, and that's not true. You need to go through probate if there are assets in the name of the person who died that do not have a beneficiary designation on them and that need to be transferred to someone else. So, for example, if I have a house that is just in my name and I pass away, there will need to be a probate done because it's real estate. So someone needs to be appointed to be able to sell that house and then distribute the assets. And so that's an example of an asset in my name that does not transfer because I have a beneficiary designation on it. And so then the other question that comes up is about whether or not a probate is necessary is whether or not there are more assets than debt. Because when there is an estate with a substantial amount of debt, then the analysis needs to be done about whether or not anyone in the family should file a probate. You're never personally liable for the debts of a deceased person, unless you've done something bad, like taken all the money after they've died. Then you might be personally liable for those assets. However, in general, a personal representative is not going to be required to pay the debts of the deceased person from their own personal assets, only from the assets of the estate. So in cases where there is an enormous amount of debt and very little assets, if none, I would encourage people to consider whether they need to file a probate at all. A creditor can file a probate and try and go after assets in the estate, but if there are no assets in the estate, by filing a probate, you still have to go through the whole probate process, which means you have to put everybody on notice that you've been appointed as personal representative. You need to send notice to creditors, and then you have to put an inventory together that basically says there are no assets, here are all the debts, and we're not going to be able to pay any of these. So it makes the person who gets appointed as personal representative jump through a lot of hoops that would not have been necessary if they had not filed a probate in the first place. So I want this to be something that you consider when you are going through the probate process, with the first question being, does a probate need to even be filed? Many people go directly to filing a probate without doing the analysis first. If it's determined that you need to file a probate, the Bernalillo County website, bernco.gov, under the probate tab, has all of the documents that would be necessary to file a probate in Bernalillo County or any other county that's relevant. And you can also use those forms if you have to file in district court. So we can file a probate in Bernalillo County Probate Court if it is an administrative probate only. So what I mean by that is I can't, as a judge in probate court, have hearings. We do probates that are situations where it's not being contested. There's a will, the person named in the will is going to be the personal representative, the will is validly executed, and I just am taking the documents, reviewing them, and then appointing the person named in the will. Or there's not a will, the family has agreed that one of the family members is going to be the personal representative. Maybe they all have the same priority. They're all the adult children of this person who died, but they're going to designate one of the children as the personal representative. They all sign off and consent to it. Then they send me an application saying, please appoint Jane, our sister, as the personal representative, and no one's fighting about this. Those are also cases that I can take as the Bernalillo County Probate Court judge. In the event that the will is being contested, there's a fight about who should be personal representative, someone's not doing what they're supposed to be after they've been appointed, those cases go to district court. So if I already have a case in front of me that ends up getting messy and people are fighting with each other, then I have to file an order transferring that case to district court so that there can be hearings heard by a district court judge. If I have a case from the beginning where we don't have consent of everyone and everybody has equal priority to serve, then we can't even do that in the probate court. But the forms that we have provided on our website are ones that can be modified to be filed in district court, so you have access to those. On the Bernalillo County website, under the probate tab, there is a PDF or a package of documents that you can download that are for a probate with a will and a probate without a will. We typically meet with clients in person at the court in order to help facilitate getting the documentation done properly so that we can get it filed. But because of COVID-19, we are doing everything via telephone, email, and mail. So when it is a will that is going to be filed with a probate, then you need to file that probate and mail the will, the original will, to the probate court. And all of that information is on our website. And in cases where there's not a will, and so we don't need the original will filed with us, you actually can PDF or email those scanned pleadings to the court, and we'll process them that way. Both packages come with very detailed instructions of the administration of the estate from start to finish. So a lot of times what happens is the person gets appointed as personal representative. They maybe are able to access the bank account, pay the bills that seem most important, and then they get stalled in the process. The packet that comes with on the probate court website actually has a flow chart that really that shows you from the beginning of the probate process all the way through the end of the administration of the estate. And that flow chart is fantastic. It really gives you an idea of what needs to be done, and when you need to do it, and who you have to let know that you've done it. And it's a very helpful tool to get you through the entire administrative process. Lawyers are used in the probate process, and if it is complicated, there are a number of lawyers in the state of New Mexico who do probate for a living, and you may need to reach out to them if it becomes more complicated than something you can do as a personal representative without counsel. But that's something you're going to have to decide, and it's based on a case-by-case basis and how complicated the underlying probate is itself with the assets. People will also ask how long a probate stays open, and that answer is it depends on the estate. So a typical probate takes at a minimum 4 months, because that's the creditor period in New Mexico. So creditors have 4 months to give you notice if they've got an outstanding debt. But probates can take longer than that, because that probate estate has to stay open until all of the assets are distributed out and all of the underlying assets issues are dealt with. And what I mean by that is this: if I'm appointed as the executor or personal representative of an estate, I need to be able to wear that hat the whole time that there are assets owned by the estate, or else I no longer have the ability to do what I need to do with them. So when people ask how long a probate takes, right now in 2020, when real estate is going very quickly, an estate may close within 6 to 12 months, because if it owns a house, that house is being put on the market, it may sell very quickly, and then the assets can be distributed, the income taxes for that person can be paid, all of those things can be handled, and the estate can be closed. But certain years during my practice, the real estate market has been very slow, and it may take months to get a house sold, and during that time, the personal representative has to be still working in that role until the closing happens, and they can make final distribution. So that is going to depend on the situation in every case. But what I do try and remind personal representatives is they have a duty to do the administration in a reasonable amount of time. So if someone gets appointed to be personal representative and then fails to take any movement and do anything, that may be a case that ends up in district court, in which somebody in the family is saying, hey, you know what, they were appointed in March and we're now in November and nothing has happened. So, you got to keep it moving, which sometimes is hard when people are dealing with death and dying, to keep that momentum going. But it's definitely something that you have to know, taking on that role, that you're going to have to complete the administration, get it done in a reasonable amount of time. And that's really based on what the underlying issues are, and get that distribution done, and then get the estate closed. On a final note, I will mention that I think that one of the things that helps the most in keeping families on the same page and keeping the conflict as reduced as possible during the administration of a state is transparency, as well as good communication. So I'm always reminding people who've been appointed as personal representative, more from a client perspective than as a judge, but we're telling people, make sure, follow that flow chart. Make sure everybody knows what's going on in the estate. Keep them informed on a reasonable basis, so that everyone feels like they're in the loop, so no one feels like there's anything going on that feels sketchy, doesn't feel like it's going the way it's supposed to. I think that just is a way to get people through what can be a difficult emotional process in the most efficient way possible.